the Evans. I'm representing the nurses that have brought this matter to court. And the reason for being in court is simply because there is a circular from the Midwifery Council that from 1st March of this month, nurses will no longer be allowed for verification except they have done 2 work experiences and some other issues. We are here in court today because we felt that it is not comfortable with the nurses. Now, the matter today was coming up for the first time. And when matters come up for the first time, it is for mention. The essence of the mention is to give a background to the court, whether parties have been served and all that. All the parties have been served. And what happened today in court is that we received an application from the first and second defendant, which is the Midwifery Council, in court this morning. We were served with that application this morning. And then we also received other applications from the Minister of Health and the Ministry. We told the court that we want to look at those applications because we have been served with those applications in court. And so the court has adjourned this matter to the 20th of May to enable us react to those issues that they have raised.
What exactly are your clients asking?
The issue is already before the court, and we will not want to dive into the merit or otherwise of the issue. But what they are simply saying is that they are not comfortable with the circular so issued by the Nursing and Midwifery Council, and that is all they are asking for.
My name is Nurse Fawale Israel. We are here this morning concerning designation. I'm here to represent Nigerian nurses, and we are here this morning because of the policy that came out of the Nurse and Midwifery Council of Nigeria to stop Nigerian nurses from seeking opportunities outside the shores of Nigeria. And of course, that policy in itself is flawed. That is the reason why we have challenged that policy in court. And we strongly believe that we are going to get justice in the court because that law in itself is flawed. It is an infringement on fundamental human rights of our fellow professionals. And of course, it is also not only stopping nurses from seeking job employment outside the country, but those who are also seeking knowledge are also affected, and this is not right in our side, and that is why we are here. The problem is not about serving Nigeria for 2 years. The problem is the Nigerian educational system. For example, I'll give myself as an example. I attended Lautech University of Technology, where a course of 5 years, I spent 10 years studying the course. I did 1 year internship, I did 1 year service. That is to spending a total of 12 years. So the labor laws in other countries, even in Nigeria, the age is already against me. So these are some of the issues that should be, that we should also consider when making policies, especially in an environment like Nigeria.
So what exactly are you asking the court?
So we are asking the court to, by default, return the verification process to the status quo so that nurses in Nigeria can seek opportunities, especially to even expand the scope of practice. For example, let me give an example. Nursing profession has about 301 career prospects globally. In Nigeria, we don't have resources. We have only explored about 14 of them. So people who want to build career opportunities in other fields, they are limited and they want to cage them down to Nigeria. And that is why we are saying no, because this is an infringement of fundamental human rights of nurses in Nigeria and it's also against the Nigerian state.
Your name again?
Nurse Fawale Israel.
Fawale Israel.
Fawale Israel. Fawale Israel.
Thank you, sir.